Welcome back, everyone. I'm Jack Shelton, a lawyer at Aegis Space Law, and I'm here to answer your space law FAQs. Here's this week's question. Imagine that a U.S. company exports EAR or ITAR-controlled spacecraft technology to a Canadian company. And this Canadian company has a Chinese employee who will have access to that technology. Is this a problem? The short answer is maybe. This is certainly something that the Canadian company needs to look into because based on these facts alone, the Canadian company could be committing a deemed re-export of the spacecraft technology to China solely because of the existence of this Chinese employee. And this could be a violation of the EAR or the ITAR. We actually posted a video on this question a few weeks ago, and we answered it just from the EAR perspective, and I realized that we needed to add a few clarifying points and address the question from the ITAR side as well. Also, in the comments below, I've linked to a worksheet that we've created, which you can download, and it will help you work through the analysis. So let's quickly review how a deemed re-export works. But first, I'll give you an example of a regular export and re-export, and then I'll give you an example of a deemed re-export. Imagine that I email technology directly from the United States to a Canadian company. This, of course, would be an export of that technology to Canada. Now imagine that they email the same technology to a Chinese company, which of course would be a re-export of that technology. So we have a regular export and then a regular re-export of the technology. A deemed re-export is a little different. A deemed re-export means that the technology stays in Canada. So imagine the situation. I have exported the technology to Canada and now it exists, let's say in this Canadian office here. And the technology is up on a laptop screen, it's up on a whiteboard, people are talking about it, they're verbally communicating the technology. And perhaps you can even see the technology in the spacecraft that's on the ground if it's opened up, and you can see the parts inside of it. Now imagine that you have a Chinese employee of the company who is working at the facility and they're able to see the technology. They're able to observe the spacecraft and the internal workings, and they're able to see how it operates, and they can hear people talking about how everything works. This could be a deemed re-export to China based on this information alone. A deemed re-export is when the Canadian company allows a third country national, who is not Canadian, to have access to the technology. However, when we're dealing with company staff, the EAR has some interesting carve-outs from the definition of deemed exports. And both the EAR and the ITAR have licensing exceptions and exemptions. First, let's look at the EAR. Under the EAR, there are 4 provisions that allow the foreign company to share the information with the third country national personnel. I've posted them up on the screen. The worksheet that we've linked to in the comments will walk you through the analysis of each of these. The first 3 of these provisions include certain fact patterns that will be excluded from the definition of deemed re-export. So, if your facts fit one of these first 3 provisions, then your activity in sharing the information with a third country national won't be considered a deemed re-export, and therefore a license won't be required. The 4th provision that I've included is a little different. It describes certain circumstances in which, if the technology was originally exported under a license, then the release of the technology to the third country national will also be included under that license. Note here that the activity will be considered a deemed re-export, but since the original export was licensed, the activity will fall under that license. A few of these provisions require that the third country national be a permanent and regular employee of the company, and we've also included that definition in the worksheet. Under the ITAR, there are 2 provisions that allow the foreign company to share the information with their third country national personnel. I've posted them up on the screen, and again, these are included in the worksheet. Under each of these provisions, the activity of making the technology accessible to the third country national will be considered a deemed re-export, which would normally require a license. However, each of these provisions provides an exemption to the licensing requirement. Like some of the provisions we referenced under the EAR, both of these ITAR provisions also apply only when the third country national is a regular employee. Note that under the EAR, the defined term is permanent and regular employee, and under the ITAR, the term is simply regular employee. Regular employee is defined at 22 CFR 120.64, and it is a little different than the similar term under the EAR. Here's another trick. The definition for regular employee that you find in the ITAR isn't actually the definition that the government is currently using. The definition, as you'll find it in the regulations, requires that the employee actually physically work at the company's facility. During the COVID lockdowns, the government realized that a ton of people work from home now, so they relaxed this requirement. Although you can't find the relaxed language in the regulation itself, you can find it in a series of Federal Register notices. We've included the relaxed standard in the worksheet, as well as a link to the latest Federal Register notice on point. One final note, if none of the provisions that we've discussed here works, then the foreign company will likely need to get a license from the US government before sharing the technology with the third country national. All right, that's it for this week's question. If you'd like to submit your questions for us to answer, just click the link in the comments below. And if you otherwise would like to chat with us, please reach out at hello@aegis.law and let us know you saw this video.